Hello Ottawa, Irene Bilinski here with RE/MAX, and today I've invited Mitch Melbourne, who's a wills and estates lawyer, to talk to us about wills and power of attorneys and how important they are. So Mitch, let's start with the power of attorney. What does that mean?
Well, thanks for having me, Irene. A power of attorney is a document, a legal document, that allows someone to act on your behalf when you are unable, whether it be for medical reasons, which is what happens most of the time for people that suffer, for example, of dementia and that don't have the capacity to actually consent to the decision or fully understand the implication or the consequences of their decisions. There are two types of power of attorneys. Okay. One is for personal care and one is for property. Most people tend to go for someone who is relatively close to the family when it comes to personal care. You want someone that knows you, knows your values, and what you would do in a situation. To give you an example, again, we were talking about physically. Let's say you get into a car accident, something unfortunately happens to you, doctor needs an answer for surgery. They need to be able to ask someone because, of course, you're not in a position to do it yourself. And then we have personal care. Personal care is, again, a situation who takes care of my property and my personal effects if something happens to me where I'm, let's say, in a coma and unable to take care of my things. And again, just to be clear, those are before you pass. Right. And that's where a lot of people seem to have a confusion about wills and power of attorney. One is for after your death as opposed to before your death. So you're always covered, and that's why when people get will or someone gets a will, they usually go for both documents, or three in this case, because you get two power of attorneys. Oh, I see. So, and it's important for people of all ages to have that power of attorney, because you could have an accident when you're, let's say, 20, or you could be 80, and you would still need a power of attorney to look after your best interests, right? Correct. So in this case, power of attorneys are usually only available for anyone over the age of 18. Okay. Before the age of 18, your parents still have the ability to make those decisions for you. Okay. And therefore, you don't need a power of attorney. Okay. Even in some cases, depending on the age, the doctor, if it's for personal care, will listen to the parents unless there is a power of attorney. Because in most cases, there's an issue with who can make those decisions, and if you can prove that you are the father or the biological mother of the child, you can make that decision. There's also a case for disabled children. So if you have someone with, let's say, Down syndrome, who again can't really understand their issues, they can't even sign a power of attorney because they never actually had the capacity to sign one, and therefore their guardian or their biological parents can make the decision for them. Oh, that's interesting. So to kind of move a little bit to the what happens once you do pass, and to come back to your question, yes, a will is important at any age. Most people don't seem to really think about the benefit of a will at an early age, given that they usually don't have much property, or they don't really have any items to pass along. Mm-hmm. Some of them won't have any children. But coming back to your original decision, your original question, I apologize. There are a situation where someone might have a child at the age of 16. That's right. That's right. Right, and that's where a case where we'll have the parents and the biological parents come in and sign, especially for the kids, but usually those documents will only be relating to the child itself or the children, and the guardianship clause, which I will get a little bit into later on. So, Mitch, what are the most important components of a will, a regular will for anybody? So most wills will usually start with a revocation clause. What's that? A revocation clause is a clause in the will that makes it very, very clear that any previous documents or wills are revoked, and that this is your final wish and will and testament. It makes it very clear to the court and anyone else, given that there's a signature at the end of the will that proves that these are your last wishes. To add to that, revocation clause, and we've seen it, we see it in wills that are drafted by the individual, sometimes will be added after because they made a mistake. And anything that's actually after the signature is invalid. So just to be clear, if someone would try to draft their own will, because you can buy kits to make sure that everything is prior to the signature. Anything following the signature will not be looked at by the court, which is something that a lot of people don't seem to understand.
Okay.
Another big clause is the executor clause, which can also usually combine with the trustee clause if there is a trust left to someone in your will. The executor is someone that you trust that will basically make sure that all of your wishes come to life. If it comes down to selling certain shares, selling property, maintaining property, giving specific gifts to someone, to charities, they're the one that literally will be appointed by the court and receive a certificate of appointment that will give them the same power that you had when you were living.
I see.
A third clause that is very, very important, especially, well, not especially, if you do have children, either under the age of 18 or, as we said earlier, someone with a disability of some sort, is the guardianship clause. A lot of young families come and see me for the simple fact that they want to make sure that if something would happen to them, to the both of them, that their kids will be taken care of. I've spoken to a lot of people and asked them, well, who do you want to be taking care of your kids if something happens to you? And they'll say, my husband or my wife. And then I point out, well, what happens if you're in the same car? What happens if something happens to the both of you at the same time? The test by law is the best interest of the child.
That's right. That's right.
And therefore, the court will have to decide, with all the documentation that is provided to them, who should be the guardian. But you can save all that trouble if you have that clause in your will that specifically name certain individual as or one, two as the guardians. I've seen a lot of time it will be the grandparents.
Okay.
One thing I usually tell my clients is to find someone that has the same values as you. And most of the time will be someone that raised you.
Right.
But you have to be careful with that as well because of their age. You know, depending on the age of the child, when you do get your will done or drafted, they might be at an older age where they don't have the capacity to be a guardian if something does happen to you 10 years down the road.
That's right.
So that's why we usually always have an alternate, or we highly advise our clients to at least review their will every 2 to 3 years just to make sure that everything is still what they want. If the answer is yes, it's very simple. And the answer is no, it's also pretty simple. Something that we do offer and most people offer is we have e-copies of the will. So making a change, because again of that revocation clause, it's really easy to sign a new will with the new changes that you would like to have implemented once you do pass. Another big clause is the beneficiary clause. Once all the gifts to charities or to specific gifts to specific individual are given out by the executor, the estate, the residue of the estate, so what is left, that amount, the properties, will be divided to the beneficiaries. That can be done two ways, and I won't go into the legal mumbo jumbo, but it can be per stirpes or per capita. What that means is, depending on the amount of or the number of names that you have, per stirpes will allow that share to stay alive as long as there's a descendant in that family.
Okay.
Therefore, if you give something to your sister and she has a child, and something happens to your sister before you pass, well, that share will go to her daughter.
Oh, okay. Okay.
If it's per capita, once that individual does pass or passes in the first 30 days after you pass, that share itself won't exist anymore.
So it'll go to the balance of the people?
Correct. So if you had 4 individuals named as beneficiaries, it would go down to 3.
I see.
And the estate, the residue, will be divided in 33% in this case. Again, this is a very, very important clause. Just again, that needs to be reviewed, because if you have, most people again just take for granted, I want to give everything to my spouse. Mm-hmm. But then life happens. You might have children, you might adopt someone, you might have a divorce, you might remarry. Those are things that you have to take into consideration.
Right.
And I use specifically the example of being remarried because it's very important for people to know that marriage cancels a will. If you get married, unless it's drafted in contemplation of marriage to that individual that is named in the will, once you get married, any previous will is automatically revoked. Because by law, everything will go to your spouse.
Wow.
Automatically. And therefore, once you have that will, let's say in your first marriage, everything would go to your children, and you get remarried, well, now everything's going to go to your spouse, and nothing will actually go to your children.
Unless you have a will.
Correct. Unless you draft a second will, or you drafted that original will in contemplation of your marriage with that individual. That is something that a lot of people don't seem to know. They have a will that they draft at an early age, and then get married 2, 3, 4 years down the road, still think that they have a valid will, but in actuality, they don't.
So they have to go and have a new one drafted.
Correct, which is usually pretty simple if again, the law firm or the individual kept an e-copy of that will. It can be drafted, because usually the wishes will be similar to what was drafted when they first came to your office.
Wow. Thank you so much, Mitch. And if you would like to get some more information from Mitch about your wills and your power of attorneys, please contact me, 613-858-1151, and I'll provide you with his contact information. And remember, real estate is all about you. Thank you.